We don't have a lacuna. In fact, Finance Bill is an omnibus amendment bill. We have about 5 or 6 legislations that Finance Bill usually amends. We have excise duty, import duty, we have value-added tax, we have income tax, we have tax procedures acts, and then we have fees and levies. These are specific legislations. Mr. Speaker, this House, if I'm approved, this House should help me bring these legislations directly touching on these specific statutes. We don't have to have a finance bill.
All right, that is the cabinet nominee for National Treasury, and Alex here says that there is a possibility of a tax laws amendment bill. But Dan Mathenge from Nyeri Town, karibu sana to the show, and talk to us about what your what your reaction is and what this means for Parliament, because like we were speaking about during the break, once upon a time there were positions, 50 CAS's positions that were quashed by the High Court for failing in public participation, because the public participation was conducted on 23 CASs. The president nominated and appointed 50 who were never vetted, never mind. Finance Act 2023 first suffered in this November, actually. It was the end of November last year, and housing levy was the culprit, and eventually Parliament enacted a law supporting that. The 3 health laws, if you're talking about the Digital Health Act, if you're talking about the Social Health Insurance Act, as well as the Primary Healthcare Act, they already challenged and successfully saw the High Court. Parliament asked to conduct public participation within 120 days, but there's a stay order. And many others that we'll be talking about. What does this say about Parliament and whether you are really listening to the people? Because this has been a predominant question since this Parliament started.
Yeah, thank you, Sam. It is not only the 13th Parliament that has passed laws which have been challenged in court and declared unconstitutional. And we look back at the history of Parliament and we can be able to pick up those cases. And our constitution, even under the old constitutional framework, the option of aggrieved citizens challenging decisions of Parliament, which is a constitutional institution, has always been open through a constitutional application in the courts. So I don't find it strange. It has happened. On the issue of CASs, I remember the Speaker of the National Assembly, after the forwarding of the CSs to the National Assembly for vetting, said we do not have a law on vetting of CSs, and therefore that decision on the CSs went back to the executive, and the executive abided by the decision of the court. And up to this point in time, no CS has been appointed.
Sure.
So today, why is the issue of CS still dominating our?
It's not dominating. I'm just telling you that there has been several decisions quashed by the courts on the question of public participation and constitutionality of the
let's go to public participation, Sam. On the issue of what our colleague here has said, among the presentations made before the Finance Committee, and they say they were not subjected to public participation. But this was a public participation exercise. Is there public participation within public participation? Number 2.
Sorry, is there?
Is there public participation within public participation? The Finance Committee has called for public participation.
Yeah.
Our friend has said they went and made presentations before the committee.
Yep.
And then he says those issues were rejected on the basis they were not subjected to public participation. But these presentations are being made in a public participation exercise.
The court found that there are new sections that were introduced after the public participation. Now, meaning, sorry, Mheshimiwa, meaning the people had not said or given their views about those sections.
Now, let's come to the powers of Parliament in lawmaking and the power of Parliament to amend laws under-made bills. So what is the court therefore taking away the power of Parliament to amend laws? And in that sense, is the court therefore legislating? And these are the issues that we are presenting to the Supreme Court, because the constitutional powers of Parliament in making laws and also in representation must be taken into context,
right,
as the courts make decisions. The other issue here, and I know I do not want to go into the subject matter of the issue because it is already before court, but I'm hoping that the Supreme Court will also make a determination on the issues, on decisions of the court that have far-reaching implications on the ability of the country to conduct its affairs. When we have the finance bill, we raise money to fund the budget. The budget is a legal instrument that has passed through Parliament. And the budgeting process starts as early as August, going with inputs from sectors, then the public, then the constitutional offices, and all of them present their budget needs in the budget making process. And it is an interesting time for Parliament. It's a very interesting time. These conversations have pricked the conscience of the nation and the constitutional office holders. But the threshold of public participation, it is time that Kenyans made an ultimate decision on what this threshold ought to be.
Is it Kenyans or Parliament? Because the courts have pronounced themselves.
The courts have pronounced themselves. But Parliament also has to take the decision on public participation also to the public.
Okay, let's listen to what the leader of majority of the National Assembly is saying about this particular decision.
Parliament is the law-making body in the country. If the judiciary desires to be the lawmakers, they have the option of resigning from the judicial seats and come and run for parliamentary seats and come make laws in this house. This era, Honorable Speaker, of judicial activism and judicial dictatorship must and needs to come to an end, Honorable Speaker.
So,
maybe some.
I mean, some.
Yeah, some, you know.
Yes.
I think, for me, I've been in Parliament for long, and I'm doing my 12th year. So let's look at the lawmaking process, because I see a gap, and that's the gap we should be addressing as panelists. What has happened, Sam, in lawmaking, once a bill is published, it goes through first reading. After first reading, is passed to the committee, the relevant committee. And that committee now, in looking through the bill, conducts public participation. The only requirement in law is that if a bill is a money bill, meaning it will have implications in taxing Kenyans, that's the only time it is referred to the budget committee. And for budget committee to make a decision, they consult the treasury. Any other bill, after second reading, when it comes now to the House, it is debated, informed by the public participation and the committee report.
Right.
Now, the gap I see is between second reading and the third reading of a bill, normally amendments are done. And these amendments are not taken back for public participation. That's why I see the gap. So I think what the court said is that if you are to make amendments, because the bill is discussed by the public during the committee stage, and these amendments are not part of the debate, then it's like the courts are requiring that if you do an amendment in the House, then before you make them, can you go back and consult the public? I think that's where the gap is. And the question is, if we are to go that direction, sir, then how long will we go through a bill?
Right.
We require a lot of time, and I think that's the question we should be answering ourselves. So what we require currently is just to come up with a legal framework on how to conduct public participation, so that the process is properly documented and we don't leave any room where the courts can come and say you did not conduct the process as expected. But currently I agree with them, because what they are saying is You introduce amendments to the finance bill after the public had given their input.
Right.
So these amendments were not subjected to public participation, which means then you do not get any public views. And I think that if we are able to address that matter, then the process should be streamlined and we'll have no problem. That's the way I look at it personally.
Yeah, and the problem, Sam, is here. So, well, I was explaining to you that for the stakeholders who appeared before the committee, we also had some other changes which were not within the Finance Bill 2024. And the recommendation from the committee was, because you're introducing something that hasn't been exposed to the whole public for discussion, we cannot carry this kind of suggestion that you're giving us now. And we understood it. So for Parliament then at the end of the day to say we had these 18 new clauses, so does public participation only, is it a preserve of only the House, or is it also for the public? Yeah. So those are the kind of questions that perhaps even the Supreme Court will give us some clarity on. Yeah.
Okay.
So you can't, on one hand, say that you've given us comments that were not in the bill, therefore have not been subject to public participation, and on the other hand, introduce new items to the bill, and therefore also still want to defend yourself and say that, you know, we are Parliament and we have the, you know, the prerogative to make laws as we wish.
Okay.
And then I think even we need to also further understand the real implications of this particular rejection, because as Mbadi says, you have various laws, and I don't know whether I will get time to go into those, because it's not just the PAYE bans. So there are, you know, a couple of other items.
I'll get to you on that, but first let me hear from the from Senator here, because Kimani Ichung'wah feels that this is judicial activism, judicial dictatorship, he calls it. What attitude should Parliament have in a situation that there are all these setbacks at the courts?
Thank you, Sam. You know, these things, sometimes when you look at them, you are like, oops, what happened? What happened to Kimani Ichung'wah? Kimani, my brother, my friend, who have been in Parliament for so long, we must understand very simple. Governance requires people who are intelligent and smart, either to circumvent the law or work within the law. Sam, are you with me? What Kimani needs to understand is this: the reason why this budget has failed and the reason why it has been deemed unconstitutional,
the Finance Act,
simply, yeah, the Finance Act, is simply because there are certain parameters that we need to follow properly. The reason why you had an uproar, the reason why you had everybody, is that when the public hearings were being done, the ones which were being done, which were rejecting that finance bill, all right, yes, some of their views were given, but a majority of the stakeholders, actually, the reports which they had given, even some of the views, the lines which were brought in, the public was not even aware. In fact, I see an article, a friend of ours called Sam Kabara. Sam has said, if you look at the way that budget has been structured, it includes all these pork barrel arrangements where funds are being thrown out to certain places which were not even initially discussed and all that. And the point that is actually coming out right now is that President Ruto's government, if there is any reason, I would actually say, congratulations for having decided that the Ministry of Finance imekushinda. This thing defeated the government to manage. If you look at the budget processes from the time we started until now, this budget has been challenged in court, and each and every issue that has been raised, the court has actually done what? Found it to not follow the Constitution. So when Kimani Ichung'wah is making noise that the judges are being activists, he doesn't even know what he's talking about. If him and our team in the Senate and the National Assembly and the Attorney General who advises the government and the people in the finance, in the Ministry of Finance and Treasury and the Central Bank had sat and look at the detailing whether we have followed the law to achieve this exercise, we would not be in the mess we are in today. So my point is very simple, Sam. If we want a country that is going to be governed well, can we follow the law? can we get the public mood? You don't just come up and say, oh, we now want to have what we call housing levy. Bap, you put it there. Oh, we are now going to increase VAT from 18% to 32%. The reason Kenyans now know what they want.
Right.
In fact, I have been saying, and Sammy, I'll repeat here today, to me, all this stuff of increasing taxes, and this is taxes and money that is being stolen. We don't need to add any taxes onto this thing. Kenya can generate its own revenue if the revenue is spent prudently, and if we manage the finances without pilfering public funds, we can actually have a balanced budget in this republic, including paying for our debts.
Yet, Senator, there were actually certain benefits to the taxpayer in the Finance Act of 2023, including what would be zero rating of LPG or the cooking gas, if you like.
That is okay.
And many others.
That which adds value to what the public wants or which is going to benefit the public, absolutely no problem.
Okay.
Sam, just two things.
Yeah.
On my to both my seniors who have served Makali Mulu 12 years, Senator Onyonka how many years in the legislation?
Maybe 17.
You continue.
Maybe 16.
This is, you asked me, what does this mean for Parliament?
Yeah.
It is very instructive to note that my senior Makau Muli, after 12 years in Parliament, accepts there is a gap in the process which he has only noticed this year. And that is why I've said the issues we are grappling with currently have pricked the conscience of the entire nation and Parliament in particular. On the issue of amendments, and that is why I've asked them how many the years they have served. How many times have they on the floor of the House at the committee committee of the whole House have they proposed amendments to the law? That has been the norm, the practice of legislation globally. Is it time to change it? That is what we need.
Let me ask you, when you're proposing an amendment on the floor of the House,
yes.
What should be the source of that amendment?
Number one, when I listen to people in my constituency, because I represent them in Parliament, I also represent other Kenyans outside my constituency because it is the National Assembly. When I have received input from them regarding a certain issue and I agree with their suggestions, then as a representative and as the practice has been in parliaments world over, I can introduce an amendment.
There's an element of public participation.
Certainly, and that is why I have said, and I agree. Then we, for the last time, I urge us as Kenyans, through Parliament, to agree, set the threshold for public participation.
Okay, just hold it.
If it means we take away the power of legislators to make amendments on the floor of the House, then it becomes the legal position for all of us.
Okay, just hold it there. Alex, what did the court say about members of Parliament who are the legislators proposing amendments and actually passing them on the floor of the House?
What the Court of Appeal said is that such amendments ought to be subjected to public participation, especially, and the court was looking at the kind of impact some of those amendments would have, and the fact that they were being introduced on the floor of the House, and the kind of reaction that the public would have. So an example would be, they also referred to some previous cases, like the Pevans case, where they were saying there was an issue of tax on betting and gaming and etc. And at that point, there was a recommendation for the tax to be 50%, and therefore we went back to the president. And the president said, we want, I would suggest 35%, and then Parliament passed it. And what the Court of Appeal was saying, even though that is the case that was being relied on by the side of the government, is that at least there was some mention of this tax within the bill, and therefore the discussion as to what the rate would be was somehow subjected to public participation. Now, come to Finance Bill 2024, and you have absolutely new amendments not related to the initial draft of the Finance Bill 2024, and then to say that those ones were also subjected to public participation, I think that's where the Court of Appeal was struggling.
So like where you'll find a member of parliament is proposing to delete and replace with a certain provision.
Yes, yeah. For example, if there was an amendment within the finance bill to say we want to reduce corporation tax by 25% as opposed to the 30% that we currently have. And then Mheshimiwa here came and said, because of the revenue gap that we have, we think this corporation tax should be increased to 35%. Now, that discussion, you can see, has already been subjected to some form of public participation, and I would think even the stakeholders would come and say, instead of 25, let's do 20. And then someone else will be saying, instead of 25, let's do 40. And then Mheshimiwa comes in and says, let's do 28. So that has already been subjected to some form of public participation. But if there was nothing within the Act on corporation tax, and then Mheshimiwa here comes and says, and then the bill goes to the first reading, second reading, towards the end, then Mheshimiwa says, I want to introduce a new amendment. I want corporation tax at 35%. And there was nothing, absolutely nothing about it. So
just for information, Sam, also, because it's important to put this clear. For your information, Sam, if you look at the Constitution, Article 114, it talks about money bills.
Yep.
I can tell you for sure, no member of parliament can amend a finance bill on the floor of the House. It's only the committee chair. Any member who proposes an amendment, you are told subject to Article 114, and your amendment will be dropped. So most of these things, which amendments you see, they come through the committee, and most will have been discussed by the executive and the committee. That's why I'm saying, for me, the big question is, the question you should be answering is, do we need then to another second round of public participation between second reading and third reading? Because if we get that one right, then even when you go to the court, it will be said that we conducted public participation. What has been happening? 4 other bills, save for money later, 4 other bills, I would be able to amend in the floor of the House, and my work will only be to convince the members of parliament to support my amendment.
Okay.
So if I amend as a member of parliament...
Let's clarify something that you just said there.
Yes.
That no member of parliament can amend a money bill unless through the committee. So when we hear that members of parliament are asked by Thursday 1 p.m. file your proposed amendments with the clerk, so that they can be considered.
What happens for money bills, if you file an amendment to a money bill, the law requires that before your amendment is discussed on the floor of the House, it has to go to the budget committee for discussion, and the budget committee, before they make their final decision, will have to consult the Treasury to confirm whether they will be able to that money will can be collected, because it will imply you collecting more taxes from Kenyans for you to implement that amendment.
Is it in practice or it's?
It is. Actually, there is always a letter written to Treasury. Yes.
Is it just in practice or it's the procedure that is supposed to?
It's the procedure. It's in law.
Where?
Public Finance Management Act. You must write to Treasury to get their opinion. Their opinion may not be binding, but always they should be saying we are in agreement or we are in disagreement, so that even when the committee says we disagree with the Treasury, Treasury opinion will have been sought.
Sam.
That's the position for money bills. But for other bills, I think the assumption is that since I'm elected by the Kitui Central people, when I make amendment, I will be making amendment for their interests. And it's like I will have conducted public participation with my people, so I'll be pushing for them for another bill.
I'll check that. Whether really, before the Finance and Planning Committee proposes amendments on the House, they are supposed to go through the Treasury. I'll check the PFM Act.
No, get this clear.
I'm not sure it has provisions on legislation, does it?
It does. Which it says at 114, says you can just go to it now, Google it. It is for any money bill.
No, you referred me to Public Finance Management Act.
Yeah, I mean that is dropped from the Constitution. You know, the Public Finance Act is an operational document for the Constitution. So it says, for any proposal which has money implication, either by a member or by a committee other than Budget and Appropriation Committee, the Budget and Appropriation Committee will look at the amendment, and if it has money implications, then they have to do a letter to Treasury for their opinion. matters that.
All right, we'll check that out.
Sam,
what do you want to say?
Yeah, I just wanted to bring something on the question of introduction of new clauses. When the bill comes before the House, at the third reading, we go through the bill clause by clause. And we either vote by acclamation or by division, where each member casts a vote on highly contested areas. At that point, when we go to vote, before the committee of the whole House, we are in addition to legislation, we are also exercising the representative power. That is why the entire House is converted into a committee, so that every constituency ideally should have the constituency's representatives' voice weighing on that matter.
Okay.
And then the majority will have their way. And that is the issue we are asking. When we talk about, I may not use the same language and vocabulary that has been used, but we are asking the judiciary, is this an element of overreach on another constitutional institution's mandate?
All right, let's listen to Dindi Nyoro and Kimani Ichung'wah on specific question of the implication of the decision on the finances of the country.
This House is law-abiding, and therefore, if the fallback position that we will have is the revenue-raising measures for 2 years ago, it therefore means we also have to adjust our expenditure to be that of 2 years ago, Honorable Speaker. And what that portends, therefore, is that if we sustain the same, we'll be in this House not very far from today. And Honorable Speaker, what we'll be coming to do is to again realign our expenditure with the same revenue that we have been contained to. And therefore that means everyone across all levels of government, in all the arms of the national government, therefore, they have to carry a commensurate burden.
When I read that judgment this afternoon, Honorable Speaker, I was left wondering and asking myself, does it mean then that all acts of parliament passed by this House post-2010 then are also nullity in law and unconstitutional? Because there is not a single act of parliament enacted by this House and even by the other House that has not had amendments in third reading. And those amendments have never gone back to the people for public participation. That is a fallacy, Honorable Speaker, of that judgment today by the Court of Appeal, with all due respect to the learned judges. But as learned as the judges are, Honorable Speaker, we must now start asking ourselves whether we are in a constitutional democracy or what kind of governance structure we have in this country.
Okay, I think he may have misspoke there because he's talking about amendments at the third reading.
Third reading is the same thing.
I don't think that's the place, is it?
Yeah, that's what we are saying. You know, before you go for second reading, second reading is where we debate in the chamber.
Then committee of the whole.
That time you'll have gone to the committee, will have conducted public participation.
Yes.
Now, when you come to second reading, after the bill passes through second reading, the next stage is third reading. Now, between second and third reading, amendments come in.
Okay.
But these are not subject to public participation.
All right. I want us to close on this, Alex, and just on the other issues that will suffer or Kenyans stand to get some relief.
Okay. Just to react first to what Mheshimiwa is saying, you see, there was a lot of hue and cry over this Finance Bill 2024. And of course, people can reflect back to what happened in Finance Act 2023. The issue is, and if you bring in, for example, the approval to send the army to the people, people are also questioning whether Parliament as it is right now is actually representing their own people. Yeah. And so there is need for checks and balances, and that's why you have the three arms. That's why you have the judiciary, that's why you have the legislature, that's why you have the executive, so that one can check the other and advise the other. And I think we shouldn't be bashing the court for providing guidance. So if we get guidance from the Supreme Court, hopefully, then perhaps it will sort out these issues of what amendments that come in at a later stage. And we need to give it also to the committee that did the public participation, because I was there. And it is true that they received a lot of comments and they were open to all these comments. And that advice that they're getting from the Court of Appeal, I think they should be taking it positively, so that as they go to the next motions of the bills that they will prepare, at least they consider that. Finally, to your question as to what other things are going to suffer because of this particular decision, you have LPG, liquefied petroleum gas, which is likely to go up because the VAT will come back to about 8%, and it was reduced through that particular Finance Act 2023. You have things like withholding tax, the timelines, because the Act was providing that we have that done within 5 days, but now that the Act is gone, we are going back to accounting for withholding tax within 20 days. You have the big issue on VAT on exported services, which Finance Act 2023 was very good in terms of providing clarity that VAT on exported services is zero rated, but now we go back to some ambiguity within our current laws, which just says exported services which are provided through business process outsourcing are the ones that are zero rated. So we get into problems with that. E-Teams, which has been something that the government has been keen on to implement. It was introduced through Finance Act 2023. And now it will go. And I don't know now, the MPs were talking about the avocado farmers, whether they are happy or not.
That's really tricky.
Then you have things like excise duty. Basically, there was a power by the Kenya Revenue Authority to carry out inflationary adjustments. That was taken out through Finance Act 2023. But now that the Act has been declared unconstitutional, does that expose the manufacturers to annual inflation adjustments, just to mention but a few.
Okay, just mention but a few. I want us to transition to the conversation that also is making headlines on the two dailies. I'm waiting for a clip for